U.S. Congresswoman LaMonica McIver was captured on video committing assault and battery on federal immigration officers back in May of this year as part of a protest outside the Delaney Hall ICE facility in Newark, New Jersey. And I have to say, with remarkable swiftness, McIver was criminally charged with 2 counts of violating 18 U.S.C. 111, which is assaulting, resisting, or impeding federal officers. And each of those 2 counts is good for 8 years in federal prison, a federal penitentiary. That's what she's looking at. And despite her criminal conduct being obviously captured on video, we're going to look at that in just a moment, McIver, more accurately, I suppose, her lawyers, have raised a plethora of legal arguments why this should all go away, why she should be legally privileged to assault federal officers and have zero legal accountability for it. And this week, yesterday, she received bad news from a Biden-appointed federal judge. So, indictment, count 1, assaulting and resisting federal officers. This would be under 18 U.S.C. 111A. We'll take a look at that statute in just a minute. That's good for 8 years. Then count 2, a second count of assaulting, resisting, impeding, interfering with federal officers. Also, section 111A1, good for another 8 years. It's a third count of assaulting, resisting, impeding federal officers, section 111A3. And I've seen it reported that she's up for 18 years in prison. And these 3 counts now make sense because if we take a look at that statute, sometimes when you commit this offense, assaulting federal officers, sometimes it's good for 8 years, and sometimes it's only good for 2 years in federal prison. So she has 3 counts. She's up for 18. It's been reported. So presumptively, 2 of those counts are each good for 8 years apiece.
The Justice Department filed charges Monday against a Democratic member of Congress, Congresswoman LaMonica McIver of New Jersey. DOJ is accusing her now of assaulting and interfering with law enforcement during a confrontation with Homeland Security officers outside an ICE detention center in Newark earlier this month.
I think the charges are absurd. You know, it's ridiculous. I was there to do my job along with my other colleagues. We have done this before. This is our obligation to do. It's in our job description to have oversight over a facility. And the entire situation was escalated by ICE. The reason why we were there is because we wanted to make sure this facility was up to par, that it was clean, that it was safe, and that the detainees there were, you know, given due process, that they were able to use the phone, that they were able to speak to their legal representation, which we found out was not happening. We were there to conduct an oversight visit, which after all of this, the chaos, they gave us a tour. You know, we were all of this, we broke in, we assaulted people, all of these things that, you know, HABA is saying and Republicans are saying, but they gave us a tour and allowed us to go in and tour the facility and speak to detainees. I would not have done anything different.
I have a couple other videos to share with you. I'll make myself smaller here. These are ones I prepared. Just watch for her fists and elbows. Punch. She just punched him in the back. Here's another one. Here's an elbow one. Bam! Bam! Pow! All right, so that's the evidence. Does that look like legislative activity to any of you? I don't think it looks like legislative activity to me. 18 USC 111, and she's charged under A1. So section A here, 1. Whoever assaults, resists, opposes, impedes, intimidates, or interferes with any person, they just mean federal officers here, designated in the section, while they're engaged in their official duties, has committed this offense. And if you commit the offense, you're subject to imprisonment for not more than a year and a fine, unless you do it by physical contact with the victim, in which case it's good for 8 years in prison. If you use a deadly weapon, it's good for 20 years, but no one's alleging that she did that. So certainly she made physical contact with 2 different officers. So that's 8 plus 8 equals 16. I'm not sure how she gets to another 2 years. Maybe it's 2 additional officers without contact. That would get you 2 more years. But this is the statute under which she's been charged. 3 counts. good for 18 years. 18 years. Factual and procedural background. The representatives and LaMonica were statutorily permitted to conduct the unannounced congressional oversight pursuant to further Consolidated Appropriations Act. And basically that's what the act says. The act says nothing in the act shall prohibit Congresspeople from having a right to conduct oversight by personally visiting these facilities. Having that privilege, of course, doesn't mean that you get to commit crimes to execute the privilege. She couldn't walk up and a guard tells her, no, I'm not going to let you in, and she shoots him in the face. If you have the authority to conduct oversight and it's not being honored by the executive branch, the proper remedy is not to commit a crime, not to commit assault and battery on a federal officer. It's to go to court and get an order. And by the way, these are all these detention facilities are secured facilities. There's no secured facility in the face of the earth where somebody can just walk up, say, I'm a U.S. congressperson, let me in, without announcement, without arrangements. They're secured. They have guards, they have locks, they have gates, they have doors, they have cages, they have cells. Obviously, you have to schedule and arrange these things. Anyone who's ever visited anyone in prison knows that. Upon arriving at Delaney Hall, LaMonica entered through the front security gate, was directed to the administrative office, where they waited for over an hour to conduct their inspection, their unannounced inspection, so nobody was ready for them. LaMonica waited in the office. A guard opened up the security gate and allowed the mayor of Newark and his security detail, he's got a posse. Why would you need a security detail if you're at a federal detention facility? Like there's no guards there? The mayor of Newark and his security detail to enter the secure premises of Delaney Hall. Approximately 40 protesters, spectators, media members. So this was intended all along, of course, to be a media circus. Amassed outside the security gate, a few feet from where the mayor and his security detail stood waiting for LaMonica. As the mayor stood within the secured area, DHS officials and ICE agents, including the agents involved here, Special Agent in charge of New Jersey, V1 would be Victim 1, and approximately 15 ICE and DHS officials approached the mayor and his security detail on foot. They advised the mayor he was not authorized on the premises and he would be arrested if he did not leave. So whereas the Congresswoman, LaMonica, has a statutory right as a member of Congress to visit and conduct oversight, the mayor of Newark doesn't have that kind of authority. There's nothing in the statute that says the mayors of cities have oversight, can visit detention facilities. So the special agent in charge of New Jersey for ICE informed the mayor, hey, listen, we let you in the gate, but you're actually not allowed to be here. You're not authorized to be on the premises. We're asking you to leave. If you don't leave, you'll be arrested for trespass. That's how trespass normally works. Of course, probably the mayor wanted to get arrested, right? This was all supposed to be a media circus. As this conversation between ICE and the mayor of Newark ensued, LaMonica exited the administrative office and walked 100 feet to the security gate to join the discussion of the mayor and the ICE officer. The ICE officer informed the group that members of Congress have a lawful authority to be in the secured area of Delaney Hall, but the mayor did not. LaMonica advised the ICE officer that they'd been waiting for over an hour. They were starving. They were starving to exercise their congressional oversight, and they believed DHS officials had delayed their inspection. Moments later, the ICE officer asked the mayor to put his hands behind his back, to which LaMonica said, "You're not arresting him. Hell no. Hell no." What authority does the member of Congress have to prevent the lawful arrest of a trespasser on federal property? Absolutely none. The mayor and his security detail, presumably armed, by the way, were directed outside the security gate and remained in the public parking lot among the protesters, while LaMonica walked toward the administrative office with several DHS agents. One of the senior Congress people, Representative 1, told the mayor, "We will be your eyes and your ears." Okay, fair enough. That's allowed. They can report back to the mayor if they wish, these Congress people. Moments later, the senior ICE officer, V1, gathered a group of DHS agents near the security gate, informed them that the Deputy Attorney General had authorized the mayor's arrest for trespassing and instructed the agents to switch on their body-worn cameras. As the ICE officer and DHS exited the secured premises through the security gate, defendant LaMonica reversed their course from the administrative office back to the unsecured public parking lot where the mayor stood among the protesters, walked alongside the senior ICE officer V1, and approached the mayor and his security detail. So does the mayor escape the trespassing arrest simply because he's exited the property? No, because the arrest is for the act of trespass. If he'd gone in there and robbed somebody and then left the property, is he not subject to arrest for the robbery? Of course he is. After an unidentified male in the crowd yelled out, "Circle the mayor!" LaMonica, the other representatives, and some protesters encircled the mayor as the officers pushed their way through the crowd to make their lawful arrest of the trespassing mayor. Again, what legal authority do these people have to obstruct these officers in making a lawful arrest? Nothing. Nothing. This is impeding. Impeding. Maybe this is one of those loose counts. LaMonica placed herself between the officer and the mayor as the officer attempted to effectuate the mayor's arrest. Is that impeding law enforcement, federal law enforcement, in the course of their duties? Performance of official duties? Of course. LaMonica told the agents, "You're touching a federal official." The audacity. They think they're royalty. They think they're above arrest. You can't touch a federal official. Presumably meaning herself. Obviously, the mayor is not a federal official. And repeatedly stated, "Don't touch us." I saw this. Of course he can touch her. He's arresting her. As the senior ICE officer was attempting the arrest, another representative stood near the mayor's right shoulder, and LaMonica wedged herself, she's a sizable gal, wedged herself between the ICE officer and the mayor's left shoulder. LaMonica and the ICE officer had physical contact that is the basis for counts 1 and 3. Those would be the ones good for 8 years each. The government alleges LaMonica faced the mayor, placed her arms around him in an effort to prevent the officers from completing the arrest, and that during her attempt to thwart the arrest, she slammed her forearm into the body of the ICE officer. The indictment further alleges that LaMonica reached out, tried to restrain the officer by forcibly grabbing him. LaMonica alleges that the officer and the agents engaged in disproportionate escalation, which created chaos and a serious scuffle involving a great deal of physical contact. In other words, she's trying to argue that, hey, if I made contact with those officers, it was completely incidental and a result of their violence. She was throwing elbows and throwing fists. This contact was not incidental. From the brief physical contact with LaMonica, following the brief physical contact with LaMonica, the ICE officer handcuffed the mayor, so made the arrest. The situation became dynamic as DHS agents forced their way through the gate by pushing away hostile protesters. During the scuffle, a second congressperson told the agents, "You can't push me." Can they push him? Of course they can. 2 DHS agents surrounded Representative 1 to shield her from the shoving of the crowd. After the senior ICE officer brought the handcuffed mayor through the security gate into a secured area, LaMonica and Representative 2 attempted to re-enter the security gate. Several protesters pushed agents who surrounded the security gate. So how's it feel now to the officers guarding the gate? That there's a breach being attempted. The government alleges that LaMonica pushed past an ICE deportation officer, that's victim 2. Surveillance video shows that as LaMonica and a second representative tried to re-enter the facility through the security gate, victim 2 blocked LaMonica from entering by forcibly pushing her back into the parking lot. And defendant LaMonica responded by pushing the officer in return. Well, if the officer is using force lawfully, are you allowed to respond with your own force? No, of course not. LaMonica was only able to re-enter the facility when a second representative wrapped his arms around her and pulled her through the security gate. Look at all this chaos. Why is this necessary? You know her office could have called and scheduled the visit. Defendant, because they wanted it this way. That's why. LaMonica and the other representatives were subsequently allowed to conduct their congressional oversight inspection of Delaney Hall later that day. And you know what they found? Nothing. They found nothing. Nothing bad was going on. Nothing unlawful was going on. The mayor of Newark was charged with trespassing. But days later, the U.S. Attorney's order dropped the charges against the mayor. Then he immediately turned around and sued for wrongful prosecution. I don't know what happened with that case, but that's how much he appreciated the kindness of the U.S. Attorney Alina Habba dropping the charges against him. On May 19th, a federal complaint charged the defendant with 3 counts of assaulting, resisting, and impeding a federal officer in violation of 18 U.S.C. 111A1, which we just looked at. On June 10th, the federal grand jury returned an indictment against LaMonica on those same charges. A month later, 2 months later, August 15th, LaMonica filed 2 motions to dismiss the case for legislative immunity under the speech and debate clause and for selective enforcement, prosecution, and vindictive prosecution. The government filed an opposition brief. LaMonica filed 2 replies to that opposition, and we had oral argument on October 21st. And this opinion is the result of all this. Count 1 of the indictment alleges that when ICE agents were attempting to handcuff the mayor of Newark, LaMonica placed her arms around him in an effort to prevent the arrest. Is that impeding and obstructing? And during that attempt to prevent his arrest, the defendant slammed her forearm into the body of victim 1 and reached out to try to restrain victim 1 by forcibly grabbing him. That would be impeding by contact, which triggers the 8-year federal sentence. So that's count 1. The indictment alleges LaMonica initially remained inside the secured area once the agents escorted the mayor outside and attempted to make his arrest. Then LaMonica hurried outside and attempted to thwart the arrest. The court must evaluate the predominant purpose of these actions. Were these legislative actions? And it relies on the video evidence attached to LaMonica's own argument to the court. Defendant argues that her sole purpose on May 9th was exercising her congressional prerogative to see for herself how ICE was treating people. LaMonica acknowledges she followed ICE out of the gates of Delaney Hall, but maintained she did so to continue her oversight. She argues this act was not a deviation from oversight, it was a doubling down on oversight. And her congressional jurisdiction was in no way limited to the premises of the facility, and undoubtedly includes conduct oversight of ICE's unlawful and irresponsible behavior. But she doesn't have statutory oversight authority over ICE generally, over ICE's purported unlawful and irresponsible behavior. She has statutory oversight authority over the facility. The government responds that LaMonica is attempting to blur the distinction between the clearly legislative act of conducting an inspection of the facility and the non-legislative act of interfering and impeding with the arrest of the mayor. Here, the predominant purpose of LaMonica's acts alleged in count 1 was not to engage in fact-finding with the oversight of the facility. DHS officials announced they were arresting the mayor, and LaMonica left the secured area of the facility and opposed the arrest outside of the facility. LaMonica's opposition to the mayor's arrest went further than the mayor's own security detail, who watched as LaMonica wedged herself, her giant body, between the mayor and the senior ICE official. LaMonica was not acting pursuant to her congressional oversight authority when she exited the security gate and made herself an active participant in a scrum in a public parking lot. As LaMonica objected to the mayor's arrest, the incident deteriorated into a serious scuffle involving a great deal of physical contact. LaMonica's strong opposition to the mayor's arrest is akin to lobbying on behalf of a particular party which remains outside the safe harbor of the speech or debate clause. Indeed, LaMonica's conduct is analogous to efforts to intervene in decisions pending before the executive branch that would mainly affect one particular party, and that's beyond the scope of speech or debate protection. Impeding an arrest, whether lawful or unlawful, goes beyond any reasonable definition of oversight and exceeds the safe harbor of legislative immunity. The court therefore rejects LaMonica's argument that the indictment's charges are inextricably connected to her legislative acts. Defendant's actions in count 1, good for 8 years in a federal penitentiary, are wholly disconnected from the oversight she and the representatives later conducted when touring the facility, where they engaged in protected fact-finding related to federal immigration policy. Her presence at Delaney Hall does not grant constitutional protection for every act performed in connection to that visit. Similarly, unavailing is defendant's argument that her oversight jurisdiction is not limited to the premises themselves and undoubtedly includes conducting oversight of ICE's unlawful and irresponsible behavior. Generally, defendants' oversight authority to inspect immigration detention facilities cannot reasonably include a scrum in a public parking lot that has no nexus to oversight or legislative activity. LaMonica further argues the indictment and evidence produced make clear that neither a court nor a jury could evaluate the evidence in this case without referring to her legislative acts. LaMonica contends the jury would necessarily hear about her focus on immigration policy and her history of congressional oversight in the area. The government insists it has no intention to introduce any of these matters into evidence because those details do not tend to make it more likely that she committed the charged offenses. So they're not probative. So for evidence to be admissible, it needs to be relevant and probative. Relevant meaning it has some association to the elements of the criminal charge or a legal defense. And probative meaning that it's the kind of information that would help a fact finder, normally a juror, determine whether or not they believe the element to be proven or not proven. It would help that make that decision whether it was more likely or less likely that a fact had been proven. In order for the defendant to prove that the defendant violated 18 U.S.C. 111A1, the government maintains it only needs to introduce evidence she used her forearms to forcibly strike a federal agent attempting to arrest someone, and she used her hands to forcibly grab and pull at that agent's jacket. And nothing about that touches on oversight activities. The Third Circuit has recognized that Supreme Court jurisprudence, as well as our own, establishes the speech or debate clause permits proof of a defendant's status as a member of Congress. Okay? While the speech or debate clause prevents the use of legislative acts against a member, it does not prevent a legislature from offering such acts in their own defense, even though he subjects himself to cross-examination. The defendant may offer evidence of her visits to other immigration facilities in New Jersey at trial without offending the privilege established by the speech or debate clause. To prove count one, the government need not and may not inquire into or introduce evidence of her legislative act of conducting an oversight inspection of the facility, which includes eliciting any details from the fact-finding she or other representatives engaged in during their tour or any conclusions drawn from the same. If the court determines a particular meeting or event constitutes a legislative act, then legislative immunity attaches, and that particular act is not admissible in the prosecution unless the defendant tries to admit it herself. Finally, LaMonica suggests that inquiry into her motives would raise significant separation of powers concerns. Defendant asked this court to extend the Supreme Court's ruling on presidential immunity, that's from Trump v. U.S., to the area of legislative immunity. But these are two separate immunities applicable to two separate branches of government, scrutinized under two separate legal standards. In other words, what the F are you talking about, LaMonica? Article 1 of the Constitution confers legislative immunity for speech or debate, while the presidential immunity doctrine is a court-created doctrine derived from the executive's Article 2 powers. The question of whether the president engages in an official action is a different inquiry from whether a member of Congress engages in a legislative act. Count 3, so that was all count 1. Count 3 does not contain any additional factual allegations, but instead incorporates the allegations of count 1. Count 3 alleges the defendant violated 18 U.S.C. 111A1 and 18 U.S.C. 2 by forcibly assaulting, opposing, resisting, impeding, intimidating, interfering with HSI special agents and ICE deportation officers while they were engaged in performance of their official duties. 18 U.S.C. 2. Whoever commits an offense against the U.S. or aids, counsel, commands, induces, procures its commission is punishable as a principal. Whoever willfully causes an act to be done is punishable as a principal. All right, this just says that if you're an accessory, you're subject to the same punishment as if you were the principal person committing the crime. So if you're in the bank robbing the bank, you're a bank robber, whatever the penalty is for bank robbery, let's say it's 20 years. If you're the driver of the escape vehicle, you're not in the bank. Arguably, maybe you're not committing bank robbery. They're making clear here that you're an accessory to bank robbery. You get punished as if you were in the bank yourself. That's all that means. Therefore, the same facts and law apply with equal force to count 3, and the outcome must be the same. Defendant's not met her burden of establishing that her predominant purpose in physically opposing the mayor's arrest was oversight or information gathering, no legislative purpose. So defendant's motion to dismiss counts 1 and 3 on the grounds of speech and debate clause immunity is denied. Count 2. The court similarly examines the predominant purpose of the acts alleged in count 2. After the mayor was arrested and brought back into the secured area, LaMonica and Representative 2 were among the crowd moving toward the security gate. Victim 2, one of the ICE agents standing guard at the gate, was attempting to prevent protesters from breaching the security gate. As LaMonica attempted to re-enter the facility, that officer forcibly pushed LaMonica back into the parking lot before LaMonica pushed the officer in response. The indictment alleges LaMonica pushed past the officer while using each of her forearms to forcibly strike that officer as she returned inside the secured area. LaMonica successfully re-entered the facility after Representative 2 wrapped his arms around her and pulled her through the security gate. Can you just envision like a giant cork going through a pipe? As the agents kept protesters from entering the security gate. While her re-entry into the secured area, defendant and the representatives were allowed to conduct their inspection of the facility following her re-entry. This court has to assess the defendant's predominant person in throwing her elbows at Officer 2 in the speech or debate. As of the date of oral argument, the factual record is still being developed. Discovery is still ongoing. The parties are in the process of reviewing 2 hours of complete video. The facts surrounding that inspection are relevant to her motive in re-entering the facility in count 2, whether her intent was related to her oversight duties. So he's not going to make a decision. The factual record is not ripe. It's not sufficiently mature to determine count 2, so he's going to wait on that and make a decision later until the factual record is further developed. I don't see how throwing your elbows into a federal law enforcement officer can under any circumstances be consistent with oversight. I just don't see it.